Hi guys, my name is Natalia Porsche and I am an immigration attorney. Welcome to my YouTube channel. On this channel, I discuss the latest immigration news, immigration law update, and other news related to immigration process and immigration reform. So if you like this video, put thumbs up, subscribe to my channel, and leave a comment. First, we have great news out of Washington, D.C. The Department of Homeland Security Secretary Alejandro Mayorkas stated in his statement that United States is ready to open its borders to Canadian and Mexican travelers, non-essential travelers who are fully vaccinated for COVID-19. So you guys, if you're planning on traveling to the United States to see your family or just for a purpose to visit, to be a tourist here, this is great news for you. So get fully vaccinated for COVID-19. That way, the United States is open for you guys to come in if you're fully vaccinated. This is great news today for Washington, D.C. From Washington, D.C., that means the United States economy should pick up and we should be back to normal. Get fully vaccinated, guys, for your non-essential traveling to the United States. So what's going on with immigration reform now? So to recap, what happened was the Democrats proposed Plan A to Senate parliamentarian McDonough. She rejected Plan A. So then Democrats proposed the registry to update the registry as a Plan B. So Senate parliamentarian McDonough rejected Plan B. So now we're on Plan C. So what happens if in Plan C would provide parole, right? Parole is not the path to the United States citizenship, which would have been provided in Plan A or Plan B. So we only have now it's a parole. So the parole is only a legal way for these people to stay in the United States, but they cannot get a green card. So it's not the path to the United States citizenship. So what happens if parliamentarian McDonough rejects Plan C? So what will happen if the Senate parliamentarian rejects Plan C? Well, the Hill published the article regarding this. What's going to happen? So if the Senate parliamentarian does not approve providing parole or another option, Democrats could vote to ignore the parliamentarian. A group of legal scholars from around the country called on Vice President Harris and Senate Democratic leadership to include immigration protection in the reconciliation package, despite the Senate parliamentarians ruling against the move, reported the Hill. The 92 scholars called on Harris, Senate Majority Leader Charles Schumer, and Senate President Pro Tempore Patrick Leahy not to overrule parliamentarian Elizabeth McDonough, whose ruling are non-binding, but for the presiding officer of the Senate to issue a ruling contrary to her advice. So the scholars wrote that the parliamentarian cannot make a final authoritative determination on that point, that only the presiding officer or the full Senate on appeal can do so, according to the Hill. To successfully appeal the presiding officer's ruling, Republicans would need to garner 60 votes. Senate Democrats would still need 51 votes to pass the final bill, meaning Harris would have to be present and presiding over the Senate to cast the tie-breaking vote. In other words, it would require all 48 Democrats in the Senate and the 2 independents who caucus with the Democrats to vote for the bill after including the immigration provisions. So what happens now after Senate parliamentarian McDonough rejected Plan A, B, and likely Plan C? So what happens now? It's not the end of the immigration reform. Well, this part, granting of green cards to a million of people, providing a path to U.S. citizenship, it's not the only options for Democrats to make this immigration reform as a part of reconciliation bill. There is another option which was originally included with the House bill. So what is this option? Well, this option is regarding unused green cards. Now the United States has about 226,000 unused immigrant visas, which were not used by people who won the diversity lottery or per the ban which were imposed by former President Trump. So now under Section 60003 of this proposed bill, an employment-based immigrant applicant with a priority date that is more than 2 years before can adjust to permanent resident without numerical limits by paying a supplemental fee of $5,000. The fee is $50,000 for the EB5 category. It's for immigrant investors. And this provision expires in 2031. A family-based immigrant sponsored by the U.S. citizen with a priority date that is more than 2 years before can adjust to a permanent residency without numerical limits by paying supplemental fees of $2,500. In fiscal year 2019, up to 94 of employment-based immigrants were adjusted of status cases in fiscal year 2019, and therefore could have benefited from the provision, compared to 3% of individuals in the EB5 category and between 8% to 15% of family-based immigrants. What happens if the applicant's priority date is not within 2 years? Well, if the applicant's priority date is not within 2 years, individuals inside the country can still file for adjustment of status for $1,500 fees and $250 fees for children under the Judiciary Committee provisions. That would provide individuals with immigration benefits such as an employment authorization document, even while waiting for permanent residence. So as you can see, this Judiciary Committee bill has other options for the Senate parliamentarian to approve. So if she did not, well, obviously she did not approve this A, B, and C plan. Well, she didn't approve yet C, but likely she will not approve it. And remind you, C proposal plan C would be to give people a parole. But the problem with downside with this C, and I don't know even Democrats will propose this plan C or not. Well, the problem with plan C is that well, there is no path to the United States citizenship. It's just basically giving people who are here in the United States, who are here illegally, or who were brought here in the United States as children, they're giving them legal documents, for example, EAD, employment authorization document, just to stay here in this country. Well, it doesn't provide any relief, and a lot of people are in need. They're pushing for this reform, so they're trying to do something. So likely, I don't even know if Plan C will be part of this reconciliation package if Democrats decide even to propose it to parliamentarian. So likely they would rather use these unused visas, which were not issued during former presidency of President Trump. Another great news that we have is news from USCIS, which were published on September the 3rd, 2021. USCIS is extending time to remove your conditional residency. So USCIS published on their website that starting September the 4th, 2021, USCIS is extending the time that the receipt notice can be used to show evidence of status from 18 months to 24 months for petitioners who properly filed Form I-751, a petition to remove conditions on residence, or Form I-829, petitioned by investor to remove conditions on permanent residency status. While making the change, USCIS says, from 18 to 24 months to accommodate current processing time for Form 751 and Form I-829, which have increased over the past year. And lastly, guys, we have new memorandum that was issued by DHS on October the 12th, 2021. This memorandum direct to punish employers who hire people who doesn't have a legal status, because the reason behind this is because the Department of Homeland Security would like to protect innocent people who were brought here as children, or who were involved as victims of human trafficking. Guys, this memo also addressed the prosecutorial discretion standard, which is relevant because we had a recent memo also issued about the request for prosecutorial discretion. So I understand the Department of Labor has recently requested support in certain ongoing workplace standard investigation, including by asking the DHS consider whether to exercise prosecutorial discretion for workers who are victims of or witness to workplace exploitation. Those individuals' requests should be considered on a case-by-case basis, weighing all relevant facts and circumstances, and evaluating those requests. The legitimate enforcement interest of a federal government agency should be weighed against any derogatory information to determine whether a favorable exercise of discretion is merited. So what we see now, more prosecutorial discretion guidelines every day issued by, almost every day, very often issued by Department of Homeland Security. So this also will, it provides direction to ICE agents provide direction to ICE agents, for example, who entered the factory and who are looking for illegal workers. Well, now they're not really punishing illegal workers. That's what the memo provides. They are more providing for the memo, more addressing is like to find out whether these people, they were victims of human trafficking or they suffered during this work for this specific employer. So this is all I have. Thank you for watching this video. If you like this video, put thumbs up, subscribe to my channel, leave a comment, and I'll see you on next video.